It's ready.
Do you want us to start?
Yeah.
Where's our producer?
Joseph. Joseph's over there.
Click. Roll.
Hi, I'm Jerry Goldstein, and I'm having a wonderful time discussing with Warren Weir.
Wolf. You got started.
You're right. Warren Weir is not that wonderful, but he's a nice
He's
guy.
a nice guy.
I'm Jerry Goldstein, and I have had a wonderful time over the past several decades knowing and practicing law in the same community with Warren Wolf. Warren Wolf is someone who has toiled in the fields of the practice of criminal defense for some time. He reached a pinnacle that few lawyers can say they enjoyed. He not only had a case accepted by the United States Supreme Court, but he won a landmark decision in Trevino versus Taylor. Warren, tell me first, where do you come from?
Well, I was born in the Bronx, not too far from Justice Sotomayor. Seriously.
I can believe that.
I'm 4 years older than she is. I went to a magnet school. She went to Cardinal Spellman High School. I went to Bronx High School of Science. But we both grew up in the projects. Her projects were a little different than mine.
She actually was a federal prosecutor, as you probably know, and was a district judge. And her first case was a case, the Spy Factory case, that was one of my cases. So I actually was in her courtroom on her first venture. But while she now sits on the Supreme Court, you had the pleasure and the privilege of arguing before that court. Warren, I think every lawyer aspires to practice before the Supreme Court. What's known as the Supreme Court bar is a fairly elite and a very small group of lawyers and advocates. But despite rumor, cases are won and lost in that court every day by lawyers who carry their own bags and who try their own cases and argue their own appeals. Take me back to what made you think that your case was cert-worthy. Why did you think that your case was a case that the Supreme Court would be apt to take?
Well, the issue is pretty simple. You know, when you think about this is the 50th anniversary of Gideon, the right to an attorney, and if the state gives you an attorney, if you're indigent, especially this is a capital case, and they're trying to take your life away from you.
That's Trevino.
Yeah. Because Gideon wasn't a capital case, but if they're going to take the client's life, the state's going to take his life, and they give him a lawyer if he's indigent, and he doesn't do a very good job, which is what happened in Carlos's case, Trevino's case, and then they, on appeal, he's still indigent, and they give him another ineffective lawyer who doesn't call out the trial lawyer. Well, you have a constitutional right, Sixth Amendment right to effective assistance of a trial lawyer. But our jurisprudence right now, and I think it's changed now, says that if you get an ineffective habeas lawyer, it doesn't matter because it's a civil proceeding, not a criminal proceeding.
How do you demonstrate that your trial lawyer was ineffective if you have an ineffective habeas lawyer raising that issue?
Well, that's the problem. And I inherited the case in federal habeas, and the attorney that did the state habeas was appointed to do the federal habeas, which is another problem. You know, if
He's
you're
supposed to grade his own paper.
how are you going to grade your own paper? And that's part of the problem previously, that the trial attorney was doing the direct appeal. And again, how can you grade your own paper? So Texas has changed that. But that's not what happened in Carlos's case.
Well, I remember in the colloquy in Clarence Gideon's case when the judge said, well, I would appoint you, if they just would charge you with the death penalty, I could appoint you a lawyer, but under Florida law at the time, I can't appoint you a lawyer for something that's not a capital case. Yours was a death penalty lawyer. And it's more than just having a cottage plant there. You're entitled to more than just a lawyer. And your issue was whether the lawyer had been effective and whether you can...
Well, the problem was, in Texas, in the habeas statute, 11.071, Section 5A, there's a procedural bar statute which has the abuse of the writ, that you can't come back on a successive writ. So basically, what it stands for, and this is what I articulated to the court, was that you have an ineffective trial lawyer, and his ineffectiveness is being insulated by the ineffectiveness of the habeas lawyer. Now, that's craziness. And coming, this was my first, this is really the unusual thing. This was the first habeas case I ever had. So,
Well, you're 62 years old. It was the first habeas case you had ever had. But the idea of the right to effective assistance of counsel, the Gideon legacy, was something that you knew and held dear. Why did you think you had, one, a case that was cert-worthy, and why did you think that you were the person that ought to carry that baggage to the court?
Well, the case was clean. It had never gone up. There were 3 other cases that were pending with similar issues, Ballantyne, Washington, and Haynes. But they had kind of gone up and down, and they were coming back up to the court on a 60B motion to show extraordinary circumstances. The history of the case is extraordinary, that we never got to, this was the first writ that we had filed with the Supreme Court. So we were coming clean to the Supreme Court with no procedural baggage. So if they were going to do something in this arena, we were the case that they were going to take, because they could distinguish our case from the other 3 cases. And the Supreme Court likes to make their decisions typically narrow to the case itself, and they look for limiting factors. And we had those limiting factors that the other cases didn't have. And about me doing the case, I lived it. I've had the case.
In the conventional wisdom is, you better hire someone who's a member of the Supreme Court bar. What made you think you were capable of, and were the lawyer that should argue Carlos Trevino's case?
One, you say it's every young woman's dream. When the case got served, my wife reminded me. We got married. I was out of law school about 2 years, and I don't know how. I don't even remember telling her this, but she reminded me. Why is it like that? She reminded me. She says, "Do you remember when we first got married? You told me that it was your dream to go to the Supreme Court," and it did. 30 years later, 35 years later.
Warren, I want to pay you 2 compliments. One, you got there because of hard work and diligence. You treated Carlos Trevino's case like you treat every case, and I've watched you over the years. You put in the time and effort. And if you had a message to young lawyers, it's like, how do you get to Carnegie Hall?
Practice.
How do you get to the Supreme Court? Hard work and diligence. I want to pay you this compliment. It was not, you don't remember telling her that, and you didn't try every case with an eye towards trying to get there. But the kind of effort you put in, dotting every I, crossing every T, not letting anything slip by your notice, you made sure almost every case was in shape to be reviewed when you got through with it, win or lose. Carlos Trevino picked you up very late in the game, and it's a testament to what you're talking about in terms of the ability for one lawyer to grade his own paper, for an ineffective lawyer to be appointed to judge and grade the paper of another ill-suited lawyer. How do you think you came along? Was it simply fate that caused you to step into this line of fire?
Yes. I've referred to it as being pulling the sword out of the stone. You know, a lot of people tug on the sword, and we tug on, all the cases that we have. You tug on the sword, and you tug, and all of a sudden it starts moving. And out it comes. And that's what happened in this case. I mean, why did it happen? I don't know.
You know, lawyers often say that, this is a case of first impression, but when you look at these cases, generally speaking, you weren't the first person that's knocked on the door. Generally speaking, these issues have arisen and they've been knocked down in lower courts over and over and over again. This was a fairly unique issue, but it wasn't that long ago when I remember standing up in courtrooms across this state and lying to the judge about whether we even engaged in plea bargaining, pre-Santabella versus New York. What do you attribute the ability to go knock on that door one more time and not accept the status quo and the accepted practice and procedure that was ongoing in Texas?
The alternative wasn't acceptable. It would have been Carlos's demise. That's that.
Death penalty cases pose a different issue. But I'll be honest with you, and this is not light flattery. I've seen you, and what happened last week is a testament to the fact, Warren, that you take on every client with the same vigorous and effective, methodical manner of defending the citizen accused. You're on the board of directors of the Texas Criminal Defense Lawyers Association. I know you came to that not early in your practice. How has that helped you, your association and affiliation with TCLA?
That's a great story. Your partner, Cynthia Orr, when she was president.
By the way, past president of TCLA.
And in ACDL, she's followed your footsteps. I just introduced her in the other room. I wasn't sure if I was reading her bio or your bio.
Well, as you and every other lawyer know, that my bio is because of her bio. But go ahead.
Anyhow, she remarked to me, she says, you need to be on the board. When she was going out as president, you need to be on TCDLA's board. I said, I've never even been on San Antonio Criminal Defense Lawyers board. She said, no, don't worry about it. I said, well, who am I? I'm just a trench lawyer, And she says, just trust me. So she got me on the board. Next thing I know, I'm going to board meetings and participating with TCDLA and speaking at seminars and what have you.
How did that play a role in Trevino's case?
About 2 years ago, well, let me go back. We were looking, when the case got started, and we started looking at potential amicus briefs, and we were looking for who can help us. And there was a committee, a group. I cast a very wide net. I got help every corner I could. Dick Burr and Seth Waxman at WilmerHale in Washington. Tony Amsterdam at NYU.
All very active in the death penalty area.
We had a conference call. We were looking at strategy. We were looking at, should we get NACDL involved? Should we get whoever involved? And we said the consensus was keep it local, keep it Texas. There's the guide to capital defense that was passed in 2006 by the state bar had a section in it which stood for the premise of our case, that the ineffective assistance of counsel claim belongs in habeas and not on direct appeal.
You read this shit that comes out of the state bar?
Well, sometimes.
Well, I'm not sure most lawyers would have picked that up. But how did that help
So
you?
anyway,
And how did that have anything to do with TCLA?
So I started to find out who was on the committee that put that guide together back in 2006. And I spoke to everybody on the committee. I spoke to the president of the state bar back, Martha Dickey, who had been the president, who really ramrodded the thing through. And the timing was very short, and a lot of people begged off and whatever. But about a year or two earlier, at board meetings, at a couple of the board meetings, Buck Files was running for president of the state bar. And of course, Buck writes the column in The Voice. I see his face every month in The Voice. He writes a wonderful column on federal law. And so I had met Buck when he was talking to us about his run for president. And when we had our conference, I said, well, I met Buck. At least he knows who I am. I met him, maybe. He's running for office. He's shaking a lot of hands. But at least he shook my hand and let me call him up and see what he says. And it's a great story because Buck says, let me see what I can do. Now, he's got to move a battleship. He's got to move the State Bar of Texas to get permission to get a writ assertion, an amicus brief done. And he had to call an executive session, and I don't know how many mountains he moved. But he gets the State Bar to write an amicus brief. And of course, in that amicus brief, they write it neutral. They said, we're not in favor of one side or the other, which say, this is what the law is in Texas. Well, the law in Texas favors our side. So anyhow, in the course of the oral argument, 3 times, Justice Kennedy, who was viewed as the swing vote, referred back to the amicus brief of the State Bar.
We should remind our kind listeners that Trevino versus Thaler was decided by a 5-4 division along the usual suspect lines, and Justice Kennedy obviously was the swing vote.
The Martinez decision was a 7-2 decision, but it was written by Justice Kennedy. The interesting thing in this case is that the decision was written by Justice Breyer, and it was much broader than what anything we had ever hoped for. They wrote it that it was national in scope. They wrote it that it wasn't just death penalty, but any case, and it didn't even have to be death penalty. It's open season. It's an amazing decision. And here's the best part of all, as a fellow cyclist. 3 years ago, I broke my hip, and I had a full hip replacement. And in the course of rehabbing, I'm working on this case. I'm at home, and the decision from the local district court judge came out, and I'm home and I'm rehabbing, and we're working on the brief up to the Fifth Circuit. But it's karma. It's just circle completed. Justice Breyer was unable to read the decision the day the decision came out. It was Justice Kennedy who wrote the decision. And the reason that Justice Breyer was not in the court was because he had broken his collarbone during a bicycle accident.
Been there, done that. Let me ask you, have you ever been to the Supreme Court before?
I have been a visitor, but I have never watched a live oral argument before. I'd been once before. In 1989, I took a group of Boy Scouts to the National Jamboree, and we went through Washington, and I told them, they all wanted to see the Hard Rock Cafe and do all that stuff. I said, no, if we're in Washington, this one for the Scoutmaster, we're going to go to the Supreme Court. So we took the general tour. But last August, I've been going to the habeas training that's put on by the administrative office since I had the case. Last August, the training was in Washington, D.C. My wife and I went and took the public tour of the court. I had called the clerk that was assisting us with filings and whatever, Kathy Tice, wonderful lady, 75 years old. She refers to the Chief Justice as Johnny. She remembers when he was a briefing attorney. So Mrs. Tice, after the public tour, I tell the guard that I have business with the court. I'm a member of the bar. And he lets me go behind the velvet ropes, and I go back to the clerk's office. And I find Mrs. Tice, and Mrs. Tice takes Teresa, my wife and I, Teresa, around, and she takes us to all these places where you got to punch keypads, private access. The general public can't get in. So we go into the court, and we go through the side. There's a side entrance, and there's some seats there, and we go in through there. Now I'm not standing where the general public is. I'm sitting where the participants are, where the attorneys are. Let me finish this story. And she takes me, and she grabs me by the wrist, and she says, come here. This is where you're going to be sitting. Cert hadn't been granted yet. She says, this is where you're going to be sitting.
She must have read your
She had. And she says, come here. Come to the podium. She says, I want you to stand by the podium. I want you to see how close you're going to be to the Chief Justice. standing at the podium, if you reach out and the Chief Justice reach out, you can almost touch hands.
You
That's
know,
how close you are.
I don't think the general public, and I don't think most lawyers, understand the intimacy of that courtroom.
It is totally intimate. There's a, you know,
Everything
it's not that big.
from the chairs to the tables to the podium. It's what you can expect. You can expect
To the quill feather that they give you, you know, that you
Which
think
is
that could have
important.
been used to write Marbury versus Madison.
well, you can see, you know, the Chief Justice, you know, sitting there in, you know, in the 18th century. You know,
Our case was so tied to Gideon. I mean, it's just so tied to Gideon. And I'm standing.
Did you ever listen to the argument by first?
I did. All these arguments are on Oyez. I listened to Gideon. I listened to Strickland versus Washington, Martinez versus Ryan, which is the case we were tied to out of Arizona. I listened to that case 100 times. I listened to it coming and going to work every day.
Well, let me talk. I've talked about your.
But let me
Go
finish
ahead,
this one.
please.
That just thinking about the case, how it's tied to Gideon, I thought, you know, I am standing exactly where Abe Fortas, his footsteps were, where Thurgood Marshall's footsteps were, when he argued Brown versus Board of Education. It's just magical. I mean, the history of that room, of that courtroom, it's just
When they
awesome.
come from behind those curtains and they're sitting there, you need to see it up close as an advocate to understand the intimacy. You're breathing on each other, and none of the trappings in most modern courtrooms are there. The tables aren't.
And they're not on high like some of the appellate courts, you know, where they're looking down on you. I mean, you're virtually on an eye-to-eye basis, and it's that intimate. And I'm serious, the world went away. It was me and the 9 of them. It was just the 10 of us together having a conversation. Because it didn't take long for them to start asking questions.
No, and they don't give you much leeway. And it is, you know, being not a court of general jurisdiction, they've got the best and the brightest teaching them every day, kids who do everything but join them in that double lock door that requires more than just one code. The idea that in that room, no one but those 9 people sit and they make these decisions.
And they don't have to worry about deference to the court above them and
They
being
are
reversed.
the court above them.
There is no court above them.
No doubt. Let me ask you, once you get there and see that, you understand the solemnity, the posturing of the whole, the spontaneous pageantry of almost everything. You know, it's in other courts when they walk in, you don't have that sense. They just almost appear out of nowhere, and I think it's a very thrilling thing. Let's talk. We talked earlier about how hard you worked to get there. Search granted. I know a little bit about this story. Let's talk about if you worked hard to get there, you got counsel from a lot of people on whether it should be you or someone else. You made the decision, I think, wisely. It was your case. No one knew it better than you. You were trained to do this all your life. This is what the culmination of that training, the fruition of all that hard work. What did you do from the day they said, bingo, start preparing? I think most lawyers have the idea that you read the briefs, you study the law, and you go and argue. Describe to us what training you did to make that presentation on your feet before the 9.
Well, I'm a solo practitioner. It's just me. And so it's an easy decision, but it's a tough decision. Because the decision that, and Bud Rittenauer, who helped, he wrote the brief, the cert.
Very right.
And we office in the same building, and we're both solo practitioners. And we talked about that. I said, look, Bud, in order to get ready for this, you know, the only way to do this the right way is just to put our practice on hold. And what I did was I sent a letter. In San Antonio, you can send a vacation letter if you're going to be out for a week, if you're going on vacation, skiing and out, and ask for one. But if
I'm old.
yeah, you don't have to worry about that. But you send a vacation letter. So what I did was I sent a vacation letter to all the courts in San Antonio and where I had cases pending in the Western District. And I said, I'm going to be unavailable for the next 4 months, because we knew the argument was going to be in February. So from October 29th to February 25th, basically, I just put my practice on hold. So what am I going to do with my time now? How am I going to
How did you?
Well, one thing was, like I said, I had never witnessed the Supreme Court argument before. But what I wanted
What's the first live Supreme Court argument you ever saw?
the one immediately before us that day. We were the second argument. So that was the first one I saw.
So how did you prepare?
I listened to it. I read transcripts. I read the transcript from Martinez versus Ryan. But like I said, Oyas.com is a wonderful, wonderful website. Every Supreme Court argument, including ours, is available to be heard forever and ever and ever.
And you've heard those words. When they say the court, they mean it. This is the court.
So I listened to hundreds of hours of tape. The Spurs are in the playoffs, right? And getting ready to play the other team. What do? You watch tape, and then you prepare. So, and I used the sports analogy a lot because, I thought, how do professional athletes get ready, for the big game, because this is the Super Bowl.
No question.
This is the Super Bowl of lawyering.
And about lawyering. I mean, not only was it Super Bowl of lawyering, but the issue involved good lawyering. I mean, what a time to know the necessity of being the quintessential lawyer.
So you do what you got to do.
What did
It's
you got to
everything.
do?
And I said, I used the poker analogy. All in. You're all in.
Did you practice?
Yes. Well, one is we talked about where things are going. How are you going to respond to these questions? Try to anticipate every possible question that the justices could ask. Who's going to ask what type of question? How do they ask the questions? Some questions come rapid fire. Justice Breyer will spin a question. He'll spend 2 or 3 minutes. All you have is 30, and he'll spend 2 or 3 minutes spinning a question, taking up, a tenth of your time before the question comes out. So you got to listen to the question. One of the things that they told us, and there's a handbook on what to do in the Supreme Court that you get when you get your case granted, and it has guidelines, things to do. One of the things it mentioned was when and General Souter told us the morning before we go in the courtroom, there's a general meeting, and he kind of reminds you some things like don't crack jokes, just don't call them judges. They're not judges, they're justices, and that's a big no-no. And don't call them by the wrong name. My friend, that's an interesting concept. Your opponent, the guy who's trying to kill my client, is referred to as your friend in the Supreme Court. And Chief Justice Roberts referred to him as my friend. It kind of took me off guard for a minute, and I thought, oh yeah, that's how you refer to the guy on the other side. But it was work. We did. There's a thing called moots. You do practice sessions
with people taking the place of
the justices.
All right.
And our bar, the defense bar, is the most giving people from top to bottom. From top to bottom.
Did you do moot court?
I did 11.
11.
Most folks will do about 2 or 3. But
October to February. 11. Well, I all in San Antonio.
Two of them were in Houston with David Dow, who's in charge of the death penalty clinic out there, who was one of the co-writers of the other amicus brief that was filed on behalf of the clinical professors I did a moot up in Austin. Those guys, Jim Marcus and Jordan Stryker and Rob Owen and Maureen Levin,
who do definitely work for a
Day-
living
for
and
a
have
living.
done it for decades.
and decades, and they studied this. They they worked me hard. I went up to Lubbock. I spoke at the Prairie Dog seminar, but the day before, Pat Metz, who's a professor at Texas Tech, who I met through TCDLA, organized 2 moots. I did it 2 days. I did 2 of them. I flew up the morning of, and I did a moot at 10 o'clock, went to lunch and did another moot at 2 o'clock. And then the next day I did a presentation at Prairie Dog.
And by the way, Metz gets a Supreme Court justice, O'Connor, Breyer, Scalia, to come to Lubbock, Texas, which, by the way, the happiness is in your rearview mirror. He gets them once a year to come there. I was there 1 year when I got to visit with Breyer and Scalia. They were both out there settling their own books. But they were both there for dinner on the same occasion.
Talking about things to read, not just listening to tapes. But one of the things I wanted to do is I wanted to learn everything I could about the justices. So their bios are on SCOTUS. There's things that have been written by them. 3 of the justices are Eagle Scouts. I'm an Eagle Scout. You know, we have something in common. I was tempted to wear my Eagle pin to the court, but I was told that we should wear no pin, that you should come clean. So I didn't wear any pin. But I felt having...
You didn't wear a morning suit.
But never having personally met them, I wanted to do everything I could to familiarize myself with them so that when I was standing in front of them, talking with them, having this conversation on a very high plane, that I felt comfortable, that I knew who they were, I knew, you know, their background, their parentage, where they went to school. They all went to Ivy League, you know, Yale and Harvard. You know, that's the thing, Yale and Harvard. And I didn't go to Yale or Harvard. I went to Alfred.
Was the dean of Harvard Law School.
That's right.
And by the way, argued her first case in the United States Supreme Court as her first case in any court, including a JV court, in the Supreme Court of the United States after she was appointed as Solicitor General. That's right. Justice Kagan.
And she did a wonderful job.
Like you, Warren.
She did, but she was wonderful during the argument. She took up for our side and gave my friend a very hard time, and obviously joined in the opinion. But I read. You know, we were talking about what else to read. When I visited, I bought one of Justice Scalia's books on how to prepare for the Supreme Court. You know, I wanted to know what they're thinking, what they're looking for. I didn't have any real hope of getting his vote, but I wanted to be able to at least, if he was asking me a question, how am I going to deal with it? The smart money was, the game plan was, you know, like take the ball out of LeBron's hands. You know, if Justice Scalia starts asking you questions, one of the things Justice General Souter told us is you have to answer the question directly. Yes, no. None of this mealy mouse, you know, lawyer talk stuff. They want an answer. Yes, no. And then elaborate, if they'll let you. Because a lot of times they won't let you. But don't try to beat around the bush. I think I counted about 15 yes or no's out of my mouth over the course of the
Did you get the impression they were posturing and arguing with each other as much as dealing with you?
I think, I've heard that before, but because this was on the heels of Martinez, they already knew where they were. They already knew where they lined up.
Where each other were, too.
And Justice Scalia never asked me a question. Justice Thomas never asked me a question.
Well, he doesn't speak up a lot.
But, so...
And unlike Dennis, he's never been told to shut up. But he doesn't say.
And Justice Breyer didn't ask me a question, which I thought was unusual, considering he was a very vocal in the Martinez oral argument. But on the flip side, when my friend got up, he grilled him unmercifully, and to the point where if you look at the questions from Justice Breyer and you read the opinion, I think it's valid to say that
Kennedy was listening.
and Kennedy was listening, that the case stands for we now have we have a right to effective assistance in habeas counsel.
And why not?
And it should be. It should be. If you get a lawyer, you should get an effective lawyer.
You know, to some extent, Warren, I think what you teach us is the old adage, if it's not the law, it should be. That there's nothing wrong with challenging statutes and even case law.
Status quo.
Challenging the status quo, challenging things that, when in practice, are contrary to a fair trial, contrary to effective representation. And I think, you know,
That's what this case was all about.
Sure, it is. It's
It's
Gideon
just-
through Strickland through
Trevino.
Martinez, you know, and it is the continuum of, you know, it's that, you know, Clarence Gideon standing there and the judge saying, well, geez, if they just, you know, imposed the death penalty, I could hire you a lawyer. It's, you know, at what point are they going to say, and then the idea that we'll say, oh, well, up to this point, now it's changed to a civil matter because habeas is quasi-civil, that now you no longer have a right to an effective lawyer, particularly when someone's life is at stake. But it seems to me that while that may be the high watermark, we shouldn't relegate second-class citizens just because it's only your life in prison rather than your life in factory.
And this goes back to the fact that this was the first case that I had. And when I first looked at it, first blush, it just didn't seem right. And all the gurus and all the, you know, the people in the know, you know, accepted the norm and were afraid or just got tired of banging their head against the wall and were giving up. And I guess maybe because I was new to it or just me or whatever, but we broke through.
Let me ask you, without giving the Carnegie Hall example, if you had to give some advice to a young lawyer, bright, industrious, hardworking, what's the path to your dream that your wife so well remembered someday? Maybe not today, maybe not tomorrow, but someday I'm going to argue my case before the United States Supreme Court.
Well, I'm a Boy Scout, right? Eagle Scout. Be prepared, right? And do your best. And that's interesting because that's the lawyer's oath. You know, when we took that oath, when we first got sworn in, I have it in my office. And if you look
read
at
it?
well, it's up on the wall. Every once in a while I look at it, but it says to do your best. Isn't that strange that the Boy Scout oath and the lawyer's oath both have that phrase in there, to do your best? And isn't that what we're supposed to do? To represent our clients zealously, to do our best, to do what our charge to in every case, you know, whether it's a traffic ticket or a death penalty case, to do our best, and that's all we can do. And if it means putting your practice aside, you know, for 4 months to get ready, then that's what you do. That's it.
As one who has watched your professional career from near and far, I can tell you that you exemplify what good lawyering is, and your life in the law